Losing a loved one is a profoundly difficult experience. Amidst the grief, the last thing you want to navigate is a complex legal system. But probate is an overwhelming yet necessary legal process to settle an estate. Our purpose here is to provide you with clear, actionable information. Please remember, this video is for informational purposes only and does not constitute legal advice. Please consult with a qualified legal professional for personalized guidance. At its core, probate is the legal process of administering a deceased person's estate. Think of it as the court-supervised procedure that ensures a person's final wishes are respected and their affairs are wrapped up. The probate journey generally follows a specific path. First, if a will exists, the court must validate it. Next comes identifying and taking inventory of the deceased's assets. Once the assets are accounted for, the estate must pay any outstanding debts, taxes, and administrative expenses. Finally, after all obligations are settled, the remaining assets are legally distributed to the rightful heirs or beneficiaries. These assets can range from a family home and savings accounts to vehicles and investment portfolios. Why is probate even necessary? At its core, probate provides much-needed security and order during a highly vulnerable time. It acts as a legal safety net, guaranteeing that a valid will is strictly enforced while protecting the estate's valuable assets from mismanagement, disputes, or outright fraud. Furthermore, probate creates a structured, fair process for resolving financial obligations. It allows legitimate creditors to make claims and be paid directly from the estate fund. Once debts and any applicable estate taxes are fully settled, the court oversees the legal transfer of ownership, ensuring properties and assets smoothly and legally pass to the rightful heirs. It's a common misconception that all assets must go through probate. In reality, many assets bypass the court process entirely, saving time and money for the bereaved. For instance, assets held in joint tenancy with the right of survivorship, like real estate or shared bank accounts, automatically transfer to the surviving owner. Similarly, assets with designated beneficiaries pass directly to the named individuals. This includes life insurance policies, retirement accounts like 401ks and IRAs, and payable on death bank accounts. Assets placed in a living trust also avoid probate, transferring smoothly to the trust's beneficiaries according to its terms. Finally, many states offer simplified procedures or exemptions for small estates. If the total value falls below a certain state-specific threshold, a full probate process may not be required at all. Navigating the probate process can feel overwhelming, but it follows a clear structure. It begins by filing a formal petition with the local probate court, asking them to officially open the estate and start the legal proceedings. Next, the law requires you to notify all interested parties, including legal heirs, beneficiaries, and known creditors. A public notice is also typically published in a local newspaper. Following this, the court reviews and validates the will. The court then appoints a personal representative, or executor. This individual assumes a strict fiduciary duty, meaning they must manage the estate's affairs honestly and in the best interest of the beneficiaries. The representative's first major task is to identify and inventory all of the deceased's assets. This may require professional appraisals to determine the value of real estate and personal valuables. Before any wealth can be transferred to the beneficiaries, the estate's financial obligations must be completely met. The representative uses estate funds to settle all outstanding debts and pay final state and federal taxes. Once all debts and taxes are cleared, the remaining assets are finally distributed to the beneficiaries according to the will or state law. Finally, a final accounting is submitted, and a judge officially closes the estate. Navigating probate means understanding who does what. First is the executor, or personal representative. Named directly in the will, they hold the vital responsibility of managing the estate and distributing its assets. Next are the beneficiaries, the individuals chosen in the will to receive those assets. But if no will exists, heirs are the ones legally entitled to inherit under state law. Creditors also play a role, stepping in to collect outstanding debts. Finally, the probate court oversees the entire procedure, ensuring all actions are handled fairly and legally. Navigating probate requires patience, as timelines can vary dramatically. A simple estate might close in just a few months, while a complex one, especially those involving family disputes or facing heavy court caseloads, can easily stretch beyond a year. Key milestones include filing the initial petition and observing the statutory waiting period for creditor claims, which often takes several months on its own. Beyond time, it is crucial to anticipate the financial costs associated with probate. Expenses typically include court filing fees, appraisal costs, bonding fees, and compensation for the personal representative. Attorney fees also play a major role and may be billed hourly, as a flat rate, or as a statutory percentage of the estate value. Keep in mind that these costs vary significantly depending on your location and the complexity of the estate. What happens if a loved one passes away without a valid will? In legal terms, this is known as dying intestate. When this occurs, state intestacy laws dictate how assets are distributed. These laws generally prioritize the closest living relatives, placing a surviving spouse and children first in line, followed by parents or siblings. To handle this process, the probate court officially appoints an administrator. This person manages the estate and distributes assets strictly according to state law. Even with a solid plan, probate can spark conflict. Will contests frequently arise when loved ones suspect the deceased lacked mental capacity or was victim to fraud or undue influence when drafting the document. Additional disputes often stem from conflicting asset valuations or fears that the personal representative is mismanaging the estate. Finally, heirship disputes over who the rightful heirs actually are can complicate the process, bringing emotional turmoil to an already stressful situation. You can often bypass the time and expense of probate with a few key strategies. Establishing a living trust is highly effective, allowing your assets to transfer smoothly to your heirs. Other powerful tools include joint ownership with right of survivorship, designating direct beneficiaries on accounts, and making lifetime gifts. But avoiding probate is just one piece of the puzzle. Comprehensive estate planning is crucial to ensure your wishes are honored and to ease the burden on your family. A complete plan encompasses wills, trusts, powers of attorney, and healthcare directives. Taking proactive steps today provides your loved ones with lasting peace of mind. Navigating probate alone can be overwhelming. A qualified probate attorney provides invaluable guidance, represents your interests, and helps you navigate the system's complexities to avoid costly mistakes. To recap, probate takes months to a year. Without a will, state law dictates heirs. The executor manages assets subject to probate. Trusts can avoid the process, and costs depend on estate size. Remember, this is for informational purposes only, not legal advice. Visit probateus.com for more resources. While probate can feel daunting during a time of loss, understanding the basics of the process is a crucial first step. Thank you for watching. Please like, subscribe, and leave your questions in the comments below. For additional resources and to find legal assistance, visit probateus.com.